Good morning, everybody. The meeting's called to order. The word of the day is methodical. We have a lot to go through. So Sherry, thank you very much. Ms. Troman, has anyone signed up for public comment?
Good morning, Commissioners. Les Truman, General Counsel. We have one person registered for public comment this morning. We have Ms. Emily Rivera. If you could go ahead, unmute yourself and begin.
Ladies and gentlemen, hearing officers of the Texas Workforce Commission, this is regarding case number 3764832-3. You've read and heard a lot of the evidence in this case. You've seen the exhibits, and now I'm providing testimony on how it's time for the commission to put this case all together. I'm representing myself in this October 21st, 2025 commission meeting regarding the April 6, 2022 case. I wasn't just laid off. I have suffered a tremendous loss. I deserve to be compensated for loss of wages and liquidated damages. This is a lengthy, ongoing case since 2022, and the burden of proof has been proven by a preponderance of the evidence. I truly believe that the evidence overwhelmingly supports this conclusion. You have all seen written email correspondence, text messages, payroll stubs, letters from licensed therapists, and numerous appeals. Employer statements that it's the IRS and that this was his process. That confirms also an inability to provide a precise wage determination for a claim related to unpaid wages, back pay, hourly, and salary wages, and overtime rates due to employers' oversight. The FLSA law requires the employers to pay overtime pay, keep accurate record keeping, and pay in a timely manner. As a result of this negligence, I have suffered and incurred serious financial losses. The evidence shows the extent of these losses: employment, financial, housing, also have incurred family deaths, and to also include mental anguish, and I ask that you award what is just and a fair amount. In conclusion, the evidence is clear. The employer was clearly negligent in computing the accuracy of the wages, and as a direct result of these miscalculations, my unemployment benefits have both been denied and has continued to be a time-insensitive legal dispute in which is causing a severe financial hardship. The employer is responsible for such a direct financial effect. I ask that you, as the commission officers, to return a decision in my favor and hold the employer accountable for their actions. Thank you for your time, consideration, and a review of my case. Emily Rivera.
That concludes our comment for this morning.
Thank you. That takes us to item 3. Now turn the meeting over to Commissioner Conant to preside over agenda items 3 through 10.
Thank you, Chairman, and good morning, Ms. Miller. I understand that we have no cases under agenda item 3. Is that correct?
That's correct. No cases under agenda item 3.
Very good. Moving on to agenda item 4, we'll now consider tax liability cases. I believe we have no tax cases on dockets 33, 34, 35, 36, 37, or 43. However, I understand there is a tax case on docket 32. Is that correct?
That is correct. For the record, Hugh Daniels, Special Program Appeals. There's one tax liability case on docket 32 and no tax liability cases on dockets 33, 34, 35, 36, 37, and 43. The case number on docket 32 is TD-23-040-1223. Chairman Esparza.
Agree with the recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Commissioner Conant.
Agree with staff recommendation.
Thank you. That concludes the tax liability cases for these dockets.
Thank you. And moving on to agenda item number 5, we have no fair housing cases under agenda item 5. Is that correct, Mr. Daniel?
That's correct.
Very good. Agenda item 6, we have, I understand, no child labor cases on dockets 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, 42, or 43. Is that correct?
That's correct. No cases.
That brings us to agenda item 7. I understand that we will start with dockets 32A, 33A, 34A, 35A, 36A, 37A, 38A, 39A, 40A, 41A, and 42A. I move that we accept staff recommendations on the wage claim cases on dockets 30 through 32A through 42A.
I second the motion, except for those cases which I am dissenting as reflected on wage claim short form dissent list for dockets 32, 33, 34, 35, 36, 37, and 43.
Excuse me, sir. This particular motion covers 32 through 42.
Okay, I'll second the motion for that original motion.
Thank you, sir.
I concur with the motion to accept staff recommendations on wage claim cases on dockets 32A through 42A, except for those cases on which I am dissenting, is reflected on these lists as short form dissents.
The motion passes with the exceptions noted. Moving on, there are no wage claim cases reported for dockets 41C or 42C. Is that correct?
Correct, no cases.
Very good. Moving on. There are no wage claim cases on dockets 32B, 33B, 34B, 35B, or 37B. However, we do have a wage claim case pulled for discussion on docket 36B. Is that correct, Ms. Miller?
Yes, sir, that is correct. 36B has one case pulled for additional discussion. It is case number 23-060878-4. Commissioner Trevino.
The decision should be modified. I do not contest that the employer's appeal should be deemed timely, and the employer established good cause for failure to appear at the AT1. I also do not contest that the claimant's wage claim is only partly timely for wages due for payments after 4/16/23, and the finding that the claimant was an employee is appropriate. However, regarding the wages due, the claimant is entitled to a retroactive payment for the raise that she was promised in 2022, but was never paid to her. The evidence established that the claimant was aware that the board had to approve the raise before it could be paid. In all of the communications between the claimant and the employer, even those that occurred after separation, there was never any indication that the claimant, or to the claimant, that the raise would not be approved. She was merely told that it could not be paid until it was approved. The evidence established that the employer continued to promise that the raise would be paid retroactively once it was approved. The claimant relied on the representations from the employer that the raise would be approved and paid retroactively, and continued to perform the additional duties that she took on at the time the raise was promised to her. Therefore, the claimant is entitled to the difference between the wages that she was paid and the raise that she was promised for the 19 weeks from when the commission has jurisdiction until the claimant's separation, totaling $7,307.78 in wages owed. Modify the WCAT. Employer filed a timely petition to reopen AT1 and establish good cause for its failure to appear at AT1. Wage claim partly timely. Claimant was in employment. $7,307.78 in wages owed.
Commissioner Conick.
Affirm the wage claim 18, timely petition to reopen, good cause, wage claim partly timely. The claimant was an employee, $544.12 in wages owed.
My apologies, I called you out of order.
That's okay.
Mr. Chairman.
We should affirm the wage claim AT2 decision. First, the employer's Rule 16 petition to reopen should be considered timely. The AT1 decision was sent to the employer's incorrect address and crucially not received by the employer's designated representative. Similarly, the hearing notice for the AT1 was also sent to an incorrect address, with the employer's representative not receiving a copy. Therefore, the employer established good cause. Regarding timeliness of the wage claim, I agree that the commission can establish jurisdiction beginning April 16th of 2023, 180 days prior to the filling date for the claim, and consider purported wages owed beginning that date. On the issue of differential pay, the claimant was repeatedly advised that any purported raise was contingent upon board approval. The board did not approve the claimant's raise, nor provide any affirmative indication that the raise was approved. As such, the wage claim AT2 denial of the claim for differential wages is supportable. Finally, I agree that the claimant was an employee, and due to the calculation error, the claimant is owed $544.12 in wages. So, excuse me, affirm the wage claim AT2 decision, timely employer Rule 16 petition to reopen. The employer established good cause. Wage claim was partly timely. Claimant is an employee, $544.12 owed in wages.
Thank you, sir. And Commissioner Conant, my apologies for calling you out of order.
Quite all right.
Just to confirm, my records, my notes show that your vote agrees with the chairman. Is that correct?
Correct.
Thank you, sir.
Short form dissent, ma'am.
Yes, sir. And that was the only case pulled for additional discussion under agenda item 7. This ends agenda item 7.
Great, thank you. So we will now turn to agenda item 8 for consideration of wage claim cases on docket 43. Understand that there are no wage claim cases pulled for additional discussion on docket 43. Is that correct?
Correct, no cases.
I move that we accept staff recommendations on the remaining wage claim cases on docket 43.
I second the motion.
I concur with the Commissioner's motion, except for the cases on which I am dissenting is reflected on wage claim short form dissent list for docket 43.
The motion passes with the exceptions noted. We turn now to agenda item 9 and the consideration of unemployment insurance cases. We will start by considering cases from dockets 32A, 33A, 34A, 35A, 36A, 37A, 38A, 39A, 40A, 41A, and 42A. I move that we accept staff recommendations on the UI cases on dockets 32A through 42A.
If I could go back to the other one, I wanted to also do my short form dissent on those contested cases for the wage claim. I don't think I said that. I think I just said I second the motion. I don't know if I need to.
Commissioner Trevino, is that agenda item 8, the wage claim cases on docket
No, that was
43?
on,
Yes,
yes,
sir,
on that
that's-
first. That's fine.
Moment. Okay, we're in the middle of the motion for agenda item 9. Let's finish the
Okay.
motion for agenda item 9, and we'll go back to agenda item 8, please.
Okay. I second the motion.
Yes, sir.
I concur with the motion, except for staff recommendations on UI cases on dockets 43A through 42A, except for those cases on which I'm dissenting as reflected on these lists as short form dissents.
Thank you. And let me return
One
to.
moment, Chair, I apologize.
Yeah, I'm gonna have to do that.
And my apologies, I'm not sure what you were just advising. I believe I needed clarification on the vote for agenda item 9, and then we can return to agenda item 8. This vote on agenda item 9 was regarding the short form dissents on those 10 dockets. And Commissioner Trevino, I need to hear the language regarding the short form dissent list in your motion.
Okay, for this one right now, I'm
For
gonna
the
second.
9. Yes, sir.
I'm going to second the motion and accept staff recommendations on the UI cases for dockets 32A through 42A, except for those cases which I am dissenting as reflected on the UI short forms or the short form dissent lists.
Thank you. And one moment. All right, so we will stop agenda item 9 at this point. Return to agenda item 8, the short form dissent list for, I'm sorry, would be agenda item 7, short form dissent. Let me just double check. Which agenda item do you want to return to?
It was going to be the previous one for docket 43. I don't believe I
Yes, sir.
did my dissenting for the reflected. So I'll read that one. I second that motion, except for the cases which I am dissenting as reflected on wage claim short form dissent list for docket 43.
Thank you. We now have complete votes on the short form dissent cases on docket 43, which would take us back into agenda item 9. starting with dockets 41C and 42C.
Fantastic. Thank you. I move that we accept staff recommendations for the UI cases on dockets 41C and 42C.
So I second the motion except for those cases, which I am dissenting on, 41C and 42C.
I concur with the motion to accept staff recommendations on the UI cases on dockets 41C and 42C.
Thank you. Your motion was non-standard, but it is legally binding.
Thank you, ma'am.
Right, the motion passes. Moving on to dockets 32B through 37B. There are UI cases pulled for additional discussion. Is that correct?
Yes, sir.
Please proceed with docket 32B.
We will start with 32B. Please proceed.
Case number 3660206, Chairman Esparza.
We should remand this case to the appeal tribunal. AT3 issued an order of dismissal based on the late employer petition to reopen without taking any testimony from the employer. In its appeal to the commission, the employer stated that all of its appeals were made in a timely fashion and does not understand why the AT decision indicates the employer missed an appeal. Based on the employer's allegation that all appeals were filed timely, we should remand this case to AT to allow the employer an opportunity to present evidence of a timely petition to reopen and for merits testimony if appropriate. Asking to remand.
The decision should be affirmed. The AT2 decision was mailed to the employer's correct address of record and was not returned to the commission as undeliverable. However, the employer's petition to reopen was filed after the appeal deadline. Therefore, the employer's petition to reopen was appropriately dismissed as late. Affirm the AT, late petition to reopen AT2. Employer did not establish good cause for AT1, chargeback.
So interested in modifying the AT, late petition to reopen, no good cause for AT2, good cause for AT1, chargeback.
Short form dissent.
So far, we haven't received a majority vote. I've got one vote to affirm, one vote to remand, and one vote to modify.
Ma'am, I can agree with Commissioner Connick.
And I still short form dissent.
Yes, sir. I have your short form dissent. Thank you.
Case number 3691538, Chairman Esparza.
We should modify the AT decision. First, I agree that the claim was valid. Concerning the job separation, the claimant worked for the employer as a supervisor in charge of safety. The claimant was separated following an incident where he failed to properly flag off a roof where his subordinates were performing hazardous duties. The claimant admitted his error, but minimized the seriousness of his conduct by noting that the workers were secured and no injuries resulted from his failure to take necessary action. However, given his role as a supervisor, the claimant knew or should have known that he was responsible for the safety of subordinates and was similarly responsible for following all relevant rules concerning safety in the workplace. Since the claimant knowingly violated workplace rules designed for personal safety, his actions constituted a misconduct connected with the work. As such, we should modify the AT decision. Valid claim, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The claimant was discharged due to alleged safety violations on the job site that was under his supervision. The employer testified that proper flagging was not used and that not all employees were tied off, as required by the employer's safety policies. However, the photographs of the job site provided by the employer supported the claimant's testimony that all the employees working on the roof were tied off to prevent falls. Therefore, the claimant admitted that it was an oversight on his part that the area was not flagged off. The claimant explained that the day of the final incident was his first day with the crew on the job site, which had been active for more than 2 years, and that the safety requirement had been at the job site for some time. Given these circumstances, the employer has failed to prove that the claimant was discharged for misconduct connected with the work. Affirm the AT, valid claim, no misconduct, chargeback.
Because the claimant was in charge of the project's safety and was aware that OSHA required him to erect a flagged safety perimeter, his failure to do so constitutes misconduct. Therefore, modify the AT, valid claim, misconduct, no chargeback, adequate employer response.
Short form dissent.
Thank you, sir.
Case number 3721505, Commissioner Trevino.
The AT decision is correct. The employer discharged the claimant due to her inability to meet their performance expectations during her short period of employment. While the employer alleged various problems that they had with the claimant's performance, they didn't provide any specific details or evidence of these issues. Additionally, although the employer alleged that the claimant violated policy by having her car windows down, that they did not provide evidence of any such policy. Furthermore, the employer did not give the claimant any warning that her performance was placing her job in jeopardy. Therefore, the employer failed to establish that the claimant's inability to perform to their standards was misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
We should reverse the AT decision. The claimant's job separation arose from performance-related concerns. While the AT attributed the claimant's performance issues to an inability to meet standards, the available record contradicts this conclusion. The evidence reveals that a pattern of neglect by the claimant in performing fundamental duties, including a failure to respond to electronic communications, to follow up with staff, and to complete assigned work, all occurring after repeated discussions and opportunities for improvement. Claimants demonstrated a lack of care in securing her vehicle on multiple occasions, further underscores a disregard for basic job responsibilities. According to established commission precedent, where the work is not complex, an employee's failure to pay attention to reasonable job tasks can constitute misconduct. Here, the claimant failed to complete nominal job duties despite various discussions and opportunities for improvement. As such, the claimant's actions constituted misconduct connected with the work. Hence, we should reverse the AT decision, misconduct, reimbursing employer not billed, adequate employer response.
The employer demonstrated that the claimant failed to perform simple job tasks, such as responding to work messages. Moreover, there's at least one documented incident in which the employer put the claimant on notice that her performance needed to improve. As such, we should find misconduct. Therefore, modify the AT, misconduct, reimbursing employer not billed, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3725570, Chairman Esparza.
We should reverse the AT decision. The claimant was paid on medical leave from June 2nd, 2023 through January 5th, 2024. Upon being medically cleared to return to work, the employer offered to reinstate her to the same position she held prior to her leave. The claimant declined the offer. During the hearing, she testified that she refused the position due to a scheduling conflict involving a difficult coworker. However, in her prior fact-finding statement and in the resignation letter she provided the employer, the claimant indicated that she voluntarily quit her job to return to school. Accordingly, because the employer had work available for the claimant and she refused due to personal reasons, she quit without good cause connected with the work. We should reverse the AT decision, voluntary leaving, reimbursing employer not billed, adequate employer response.
The decision to qualify the claimant for benefits is supportable, whether her job separation is viewed as a quit or a discharge. The claimant took approved medical leave because of an illness caused by stress due to the bullying in the workplace. The employer did not provide any evidence that they addressed the claimant's concerns or attempted to correct the issue during the time that the claimant was on leave. Additionally, the employer did not allow the claimant to return to work for a month after the claimant informed her manager that she was medically cleared to return. When the claimant was finally told that she could return, she chose not to do so because the working conditions had not been addressed by the employer. Therefore, the claimant had good cause connected with the work for quitting. Affirm the AT, no voluntary leaving, bill reimbursing employer. However, since the employer delayed the claimant's return to work for over a month after she was medically cleared to return, the separation could be viewed as a discharge. The employer gave no explanation for the delay in processing the claimant's return to work and presented no evidence that the claimant engaged in any action of misconduct connected with the work. Modify the AT, no misconduct, bill reimbursing employer.
So the case should be reheard because the claimant did not meet her burden of proving that either one, the bullying created intolerable conditions, or two, the bullying caused her medical condition. The record suggests that the claimant could provide this additional evidence. Therefore, rehear to develop the record on the alleged workplace bullying and to obtain documentary evidence that the claimant needed to leave her position for medical reasons.
I'll support Commissioner Connett's rehear.
Thank you. Majority vote is to rehear the case.
Case number 3764832, Commissioner Trevino.
The decision is not fully supportable. Regarding the underlying timeliness issue, the timeliness sanctions should not apply because the TWC did not issue the statement of wages and the notice of wage investigation findings until May of 2023, which was nearly 9 months after the claimant filed her initial claim. The Commission's delay in issuing these to the complainant constitutes Commission misinformation, and the complainant's appeal should be deemed timely. As to the wage credits issue, the claimant submitted additional documentation that should be admitted into evidence, and the record should be further developed regarding the claimant's entitlement to any additional wage credits, whether the claimant was eligible for an alternative base period. Therefore, this case should be reheard in order to enter the documents into evidence and take additional testimony on these issues. Modify the AT, timely claim and appeal, rehear.
The AT decision is supportable. I agree that the claimant's appeal to the appeal tribunal was timely. Concerning the wage credit issue, the claimant simply had insufficient wage credits in at least 2 calendar quarters to be monetarily eligible to file a claim. Wage credits are recognized in the quarters in which they are paid by employers. Although the claimant performed several days of work in December of 2021, her first paycheck did not come until early in January 2022, which was in a different calendar quarter. TWC does not have the option of ignoring the statutory requirements in the labor code. Since the claimant had wages in only 1 quarter in the base period, and since her total base period wages did not equal at least 37 times her weekly benefit amount, her claim was not allowed. Accordingly, we should affirm the AT decision. The claimant's appeal to the appeal tribunal was timely, no additional wage credits.
Would like to modify the AT, late appeal, no additional wage credits, memo to investigate whether the claimant is eligible for an alternative base period.
We have a majority vote that the appeal was timely. And we also have a majority vote that there were insufficient base period wages, although there are different commissioners' majorities on those issues. Therefore, the majority vote is timely appeal, no additional wage credits. And then a memo was requested by one of the commissioners. So timely appeal, no wage credits.
Okay. So I'll short form dissent, ma'am.
Thank you. And would you like to short form dissent on the wage credit issue only?
Yes, ma'am.
Thank you, sir. And because you didn't vote the same on the timeliness issue, Commissioner Connett, you could also short form dissent on the timeliness issue if you wish.
No, thank you.
Thank you. That was the last hold case for additional discussion on docket 32B. Moving on to 33B.
Case number 3489449, Chairman Esparza.
The commission should find the employer's CA appeal timely. The employer provided testimony that it did not receive the AT decision in the mail and that it checked the mail daily. The employer should not be viewed as having sat idly by because it had appealed once it discovered the outcome of the case an increase in its tax rate. Because the employer testified that it did not receive the AT decision, we should find the employer's CA appeal timely and resubmit the case.
The employer's appeal to the commission should be dismissed as late. The decision was mailed to the employer's address of record on 3/27 of 23 with an appeal deadline of 4/10 of 23. The employer did not file its appeal until December of 2023, which was over 8 months late. Although the employer testified that they did not receive the decision in the mail, they provided vague and inconsistent testimony about the reasons for their late appeal. Since there is no good cause exception to the timeliness rules, the employer's appeal should be dismissed as late. Dismiss the employer's CA appeal as late. Leave the AT decision in full force and effect.
Modify the AT, late CA appeal, no timely protest.
The majority vote is to dismiss the commission appeal as late.
Short form dissent.
Yes, sir.
Case number 3672056, Chairman Esparza.
We should modify the AT decision. First, I agree that the employer established good cause for missing the AT hearing. During the job separation, the claimant was terminated for advertising her personal business venture on social media. Claimant's proposed business involved performing the same service as the employer and posed a direct conflict to the employer's business interests. Commission precedent has long held that a claimant's participation in a business which competed with the employer could constitute a conflict of interest in their involvement, a mismanagement of their position of employment. Here, the claimant's formation of a business which provided the same service as the employer clearly presented a conflict of interest and was not in the employer's best interest. As such, we should modify the AT decision. The employer established good cause for missing the AT hearing, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. I do not contest that the employer established good cause for its failure to appear at AT1. Regarding the job separation, the claimant was discharged for violating an agreement the claimant made with the employer, which restricted her from working for or operating a competing business within 10-mile radius of the employer's business. The employer based their allegations on social media posts made by the claimant, but provided no evidence that the claimant performed competing services or that the claimant offered any services within the area that was restricted by the agreement. The claimant denied violating the agreement and testified that she discussed the services that she offered with her manager and was told that they did not violate the agreement. Therefore, the employer has failed to establish that the claimant engaged in actions that could be considered misconduct connected with the work. Affirm the AT, employer established good cause for AT1, no misconduct, chargeback.
Modify the AT, good cause, misconduct, no chargeback, adequate employer response.
So the majority vote disqualifies the claimant. It's unanimous on the good cause issue.
Short form dissent, ma'am,
Would you like to short form dissent on the separation only?
on the separation only. Correct, ma'am.
Thank you.
3700674, Commissioner Trevino.
The decision is not supportable. When the claimant filed his claim for benefits, he named his last employer as Uber. However, working as a marketplace contractor is not work performed in employment, and Uber is not considered an employer for such contractors. Therefore, the correct last employer was not provided for the claim. As such, since the correct last employer was not named on the claim, and since all the claimant's wages were reported by another employer, the AT decision should be set aside, the determination voided, and the claimant's work separation from the correct last employer investigated. Set aside the AT decision, void the determinations, memo to have the correct last employer named on the claim, and the claimant's separation from the employer investigated.
We should affirm the AT decision. The claimant stopped working due to lack of acceptable transportation when his vehicle broke down. Because the claimant quit for personal reasons, he quit without good cause connected with the work. Affirm the AT decision, voluntary leaving overpayment.
The claimant's work as an independent delivery contractor for a marketplace platform was not in employment. Thus, there was no separation and the underlying ruling is void. The claimant's honest reporting of gig work earnings should not trigger a new claim and result in the claimant being disqualified from the receipt of benefits. Therefore, set aside the AT, void the continued claim, no overpayment.
One moment, please. Just to clarify, this was an initial claim, not a continued claim. If this particular claim is set aside, there would have to be a new investigation into who the correct employer would be.
That's fine. I'm happy to concur with Commissioner Trevino in that regard.
Thank you, sir.
Short form dissent.
Yes, sir.
Case number 3712965, Commissioner Trevino.
The AT decision is not supportable. The claimant was informed upon hire that she had to pass the exam to retain employment. However, she was also told that at the time of hire that she would have 3 chances to pass the exam. It was only after accepting the job and preparing for the exam that she was told that she was required to achieve a threshold score on the first attempt to be allowed to take it again. The claimant testified that this information about the required score to retake the exam was not included in the employer's written policy or in her conversations with the employer prior to accepting the job, and the employer failed to present any evidence to the contrary, despite being given the chance to do so at a commission-directed rehearing. The complainant fell short of the required score on her first attempt and was not allowed to retake her exam. Therefore, because the claimant was told at hire that she would have 3 chances to pass the exam and was not informed of the minimum score requirement, the claimant's failure to pass the exam on the first attempt does not constitute misconduct connected with the work. Reverse the AT, no misconduct.
The AT decision should be affirmed. The claimant was aware that passing the exam in question was a condition of employment. Claimant admitted to receiving written company policy requiring passing the exam. Claimant failed to pass the exam. Consequently, the claimant did not meet the employer's known condition of employment. Pursuant to commission precedent, claimant's action constituted the equivalent of misconduct connected with the work. We should therefore affirm the AT decision misconduct.
So this case is an outlier from the typical failure to pass case. Under these circumstances, the claimant's testimony that she expected to have 3 test attempts in accordance with the employer's test-taking policy should be given greater weight. The employer has not proved the claimant engaged in misconduct because it provided no testimony nor evidence of its test-taking policy. Therefore, reverse the AT, no misconduct.
Short form dissent.
Yes, sir.
Case number 3716055, Commissioner Trevino.
The decision should be modified. I agree that the claimant established good cause for missing AT1 due to having to take her child to school at the time of the hearing. However, regarding the job separation, the evidence clearly showed that the claimant had to quit this job to care for her terminally ill husband on a full-time basis without having alternative care available at the time she resigned her position. Therefore, since the claimant quit to care for her terminally ill spouse, and since she had no alternative care available at the time that she resigned, she should be qualified for benefits under Section 207.046, and the employer's account protected from chargeback under Section 204.022. Modify the AT. Claimant had good cause for AT1, no voluntary leaving, no chargeback.
We should modify the AT decision. First, I don't contest the good cause finding concerning the job separation. Claimant quit to care for her terminally ill spouse. Claimant submitted medical documentation of her husband's status and testified that no reasonable alternative care was available. Because the claimant has met the requirements of Section 207046 of the Act, the claimant should be qualified for benefits and the employer's account should be protected from charge. Modify the AT decision. The claimant had good cause for a non-appearance, no voluntary leaving, no chargeback, separation due to caring for a terminally ill spouse.
Modify the AT, good cause, no voluntary leaving, no chargeback because of the care for the terminally ill spouse.
Thank you. We have a unanimous decision.
Case number 3716-439. Chairman Esparza.
We should affirm the AT decision. There's no doubt that the claimant was in a very difficult position having quit to care for her ill spouse. However, if she was not available to accept full-time work, she would not be eligible for unemployment benefits. Claimant testified that she was her husband's primary caregiver and was not able to return to work. The claimant may have secured some assistance with caring for her husband for a period of time, but in fact-finding statement, she stated that, even with help, part-time work was the only option. Therefore, since the claimant was not available to accept full-time work, she was not available for work, and ineligibility is appropriate. Affirm the AT decision availability, not eligible, beginning February 4th of 2024.
The AT decision should be modified. The claimant's husband was on hospice care due to terminal illness, and the claimant did not have alternative care available for her husband at the time that she quit her job or when she filed her claim for benefits. She was then able to secure someone to help care for him to allow her to work. The claimant informed the Commission in her appeal on 2/15/24 that she was able to arrange care for her husband. Therefore, the ineligibility should be closed effective 2/17/24. Modify the AT, claimant not available for work 2/4/24 through 2/17/24.
I'd like to affirm the AT, claimant not available for work beginning February 4, 2024.
Short form dissent, ma'am.
Yes, sir.
Case number 3735452. Chairman Esparza.
We should rehear develop the record for the final incident. Claimant was discharged for violating the employer's policy. Fact-finding statements allege that the final incident occurred when the claimant failed to check out a guest and was terminated for insubordination. However, final incident was not adequately developed by the AT. Accordingly, we should grant a rehearing to further develop the record regarding the final incident that led to the claimant's discharge.
The AT decision is supportable. The employer discharged the claimant, alleging that the claimant failed to follow proper checks and process for the hotel guest and for displaying poor attitude. The claimant denied the allegations of misconduct. The employer provided mostly secondhand testimony, and firsthand testimony that they provided was vague and inconsistent. Since the employer failed to provide consistent testimony or any direct evidence that the claimant was solely responsible for failing to adequately check out a guest from the operating system, the employer has failed to prove that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
I concur with Chairman Esparza's vote to rehear.
We will rehear the case.
Case number 3735611. Commissioner Trevino.
The AT decision is not supportable. The claimant has credibly and consistently testified that she attempted to submit her appeal online prior to the appeal deadline, but that technical issues delayed her appeal and she did not get to go through until midnight, 12 a.m. Since the claimant submitted the appeal prior to the appeal deadline, and since her appeal was delayed by technical issues with the Commission's system, and since the claimant's appeal was received at most 60 seconds after the appeal deadline, the claimant's appeal should be deemed timely and the case resubmitted for merits testimony. Reverse the AT, timely claimant appeal, resubmit.
We should affirm the AT decision. Under our timeliness rules, the appeal date for an appeal submitted electronically shall be the date and time the appeal is received by the agency. Here, the claimant's appeal was received on midnight on the day after the deadline. Despite receiving the determination within a week of its issuance, the claimant delayed filing an earlier appeal because of personal reasons. Because there's no good cause exceptions to the timeliness rules, the claimant's appeal is not timely. Thus, we have no jurisdiction to consider the underlying merits. From the AT decision, late claimant appeal, misconduct, no chargeback.
We should deem the claimant's appeal timely because she made a diligent effort to submit her appeal on time and was only 1 minute late due to technical issues with the TWC appeals portal. Therefore, modify the AT, timely appeal, resubmit.
Short form consent.
We will resubmit the case.
Okay.
Case number 3739187, Chairman Esparza.
We should reverse the AT decision. The claimant violated district policy by striking a student with an object as a form of discipline. The employer investigated the incident and reviewed video surveillance which proved the inappropriate conduct occurred. Based on the gravity of the situation, we should reverse the AT decision, misconduct, no chargeback, adequate employer response. In the alternative, we should rehear this case for employer to provide video evidence and witness testimony concerning the final incident. Review of the video could prove dispositive and resolve any doubt about the claimant's actions. Rehear.
The decision is correct. The employer discharged the claimant for allegedly hitting a student with the broom. The claimant provided credible sworn first-hand testimony denying the employer's allegations and testified that she lightly tapped the student in a playful manner and that the student was not harmed. Since the employer only provided secondhand hearsay testimony, the employer has failed to provide sufficient evidence to establish that the complainant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
The allegations against the claimant here are very serious and troubling. Still, I think there's some evidentiary and procedural concerns that warrant a rehear. Therefore, rehear for the employer to submit firsthand testimony and or the video of the final incident.
We will rehear the case. And that was the last case pulled for additional discussion on docket 33B, moving to 34B.
Two down.
Case number 3046791, Chairman Esparza.
We should modify the AT decision. First, I agree that the employer established good cause for missing the AT hearing. Asserting job separation, the employer provided substantial evidence to show that the job separation was a result of complications arising from the COVID-19 pandemic. Since claimant's job separation was the direct result of a presidentially declared disaster, we should find claimant qualified for benefits and the employer's account protected from chargeback. Modify the AT decision. The employer established good cause for missing the AT hearing. No misconduct, no chargeback, disaster.
The AT2 decision is correct. First, I agree that the employer established good cause for missing AT1. Regarding the job separation, the claimant was separated from his job after his last assignment ended, and he properly reported for a new assignment the following day. However, the employer did not have any further assignments available for the claimant at that time. Since the claimant was involuntarily separated due to a lack of further work when his last assignment ended, the claimant's separation were for reasons other than misconduct connected with the work. Affirm the AT, employer established good cause for AT1, no misconduct, chargeback.
The employer's account should not be charged because the separation was the direct result of the COVID-19 disaster. Therefore, modify the AT, good cause, no misconduct, no chargeback.
It is a pay and protect, and the good cause issue was unanimous.
Yes. I'll agree with the other.
Thank you. The entire decision is unanimous.
Case number 3138553, Chairman Esparza.
The commission should rehear this case. Claimant was terminated for smoking in a company vehicle. Although there was a video of the final incident, the video was not produced for review. Similarly, although the employer produced its smoking policy, the document was submitted in its appeal to the commission. Since admitting and reviewing the employer's additional evidence is necessary to properly render a decision on the job separation, we should rehear this case to review the employer's additional information. Rehear.
The decision is correct. The employer discharged the claimant alleging that he violated employer policy by smoking a cigarette in a company vehicle. The claimant provided sworn firsthand testimony denying the allegations that he had smoked a cigarette in the vehicle, but that he was only using smokeless electronic cigarette. The claimant also testified that he was unaware of any policy forbidding the use of electronic cigarettes, and the employer did not provide any evidence as such policy. Since the employer did not provide any direct evidence that the claimant's actions violated any applicable law or specific policy, the employer failed to establish that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
This case is distinguishable from other safety cases on today's dockets because it's unclear whether the employer condoned the alleged violation. As such, this case should be reheard to allow the employer to develop the record on whether they acquiesce to the claimant's use of electronic cigarettes. The employer should also be given the opportunity to resubmit the unclear dash cam images. Therefore, rehear to develop the record on whether the employer condoned the claimant's use of electronic cigarettes, and for the employer to resubmit the unclear images.
We will rehear this case.
Case number 3436120, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant had good cause for missing AT2 because she could not call in due to technical issues. Regarding the claimant's failure to appear at AT1, the claimant's petition to reopen stated that she was prevented from appearing due to an emergency, and in her testimony, the claimant testified that the emergency that what prevented her from calling in for the hearing was that she had her infant son, her and her infant son both became ill during the night before the hearing. Since the claimant missed the hearing due to illness, the claimant was prevented from participating in the hearing by circumstances beyond her control and has established good cause for her failure to appear at AT1. Modify the AT. Claimant established good cause for her failure to appear at AT2 and AT1. Resubmit.
The AT decision should be modified. I don't contest the good cause issue in relating to the claimant's non-appearance at AT2. As to the good cause issue for the claimant's non-appearance at AT1, the claimant testified that she was unable to attend the AT hearing due to circumstances connected with she and her son being violently ill. As such, the claimant had good cause for a non-appearance. We should therefore modify the AT decision. The claimant had good cause for a non-appearance for AT2. The claimant had good cause for a non-appearance at AT1. Resubmit.
Modify the AT, good cause for AT1 and AT2. Resubmit.
We will resubmit the case.
Case number 3654927, Commissioner Trevino.
The claimant's continued claim involving his work for a marketplace employer in self-employment. As such, there was no separation from employment, and continued claim dated March 11, 2023 should be voided. Set aside the AT decision, void the continued claim, no overpayment.
We should affirm the AT decision. The claimant stopped working due to his vehicle needing repairs. The claimant quit for personal reasons. He quit without good cause connected with the work. Affirm the AT decision, voluntary leaving overpayment.
The claimant's work as a gig driver was not in employment, thus there was no separation. The claimant's honest reporting of sporadic gig work should not result in the claimant's disqualification. Set aside the AT, void the continued claim, no overpayment.
Short form dissent.
Yes, sir.
Case number 3669329, Commissioner Trevino.
The AT decision is not supportable. The claimant was unable to participate in the AT1 hearing because she registered 4 minutes late. The claimant was dealing with medical issues and attempted to register timely. Therefore, the claimant established good cause for missing AT1. as she made a good faith effort to participate in the hearing. Reverse the AT, claimant established good cause for AT1, resubmit.
We should affirm the AT decision concerning good cause, although the claimant timely received the AT hearing packet, she failed to follow instructions for registering and missed the scheduled hearing. Since the claimant missed the AT hearing due to circumstances which are directly within her power to control, she did not establish good cause. Concerning the job separation, the claimant was previously counseled about her professionalism. Therefore, she became insubordinate, unprofessional, and disrespectful towards her supervisor during a Zoom call. Since the claimant was previously counseled regarding her unprofessional conduct, her continued insubordinate behavior constituted misconduct connected with the work. As such, we should affirm the AT decision. The claimant did not establish good cause for missing the AT hearing. Misconduct, reimbursing employer not billed.
The claimant has not established by credible and persuasive evidence that she was prevented from timely calling into the hearing by circumstances beyond her control. I find no reason to disturb the AT decision. Therefore, affirm the AT, no good cause, misconduct, reimbursing employer not billed.
Short form dissent, ma'am.
Yes, sir.
Case number 3680401, Commissioner Trevino.
The AT decision is not supportable. The claimant provided credible and consistent firsthand testimony that he turned in incomplete paperwork because he was instructed to do so by a supervisor. The supervisor acknowledged that the claimant was unable to complete the safety ride because of the supervisor's instructions to perform other duties. And even after completing the investigation, the employer delayed the discharging of the complainant for a month. The employer was given a rehearing to allow them to submit additional evidence to support their contention that the claimant falsified documentation and to address the delay, but the employer did not appear. Since the employer failed to meet its burden of proving that the claimant falsified the report, and since the employer discharged the claimant at its own convenience instead of at the end of the investigation, the weight of the evidence established that the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, charge back.
The AT decision should be modified. The claimant was fired for falsification of records. The employer presented a witness who stated that the claimant admitted to the falsification in his presence. While the claimant offered varying denials, the employer's evidence has been consistent. The claimant reported that he had completed a safety ride, which did not happen. Moreover, any delay between the time of the final incident and termination was reasonable, as it appears the employer was going through its customary internal process intended to protect the claimant's rights. As such, the weight of the credible evidence established that the claimant's actions constituted misconduct connected with work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Modify the AT, misconduct, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3683051, Commissioner Trevino.
The AT decision is not supportable. Regarding the good cause issue, the claimant made a good faith effort to call in a timely for the hearing, but his registration did not go through until 1 minute after the hearing start time. Therefore, the claimant had established good cause for his missing the AT1. Regarding his availability to work due to the lack of child care, the claimant told the claims examiner that he did not have daycare for his child because he was unemployed and had no income. Therefore, the claimant testified that at the time of the hearing that he had arranged child care with his parents. He also noted that they would be out of town for an extended period. The claimant was not questioned regarding whether he could obtain child care if he were to be offered a job, but that is a reasonable conclusion based on his assertion that he only did not have child care due to the lack of income. The claimant was not required to have child care while searching for work in order to be available, but only to have the ability to accept full-time work. Therefore, the claimant should be found to be available for work. Reverse the AT, claimant established good cause for AT1. Claimant is available for work due to child care. Dismiss the moot complainant's appeal to availability determination regarding school attendance. In the alternative, I could agree to rehear this case in order to question the claimant regarding whether he could obtain childcare if he was afforded a full-time employment.
The AT decision should be modified. I don't contest the good cause issue. As to the first availability issue, the claimant was clear in a fact-finding statement to the commission he could not work full-time due to his child. In addition, the claimant's testimony was unclear whether he could arrange childcare if he were to obtain full-time employment. As such, the claimant was not available for work. The remaining availability issue regarding the claimant's school should be dismissed as moot. We should therefore modify the AT decision. The claimant had good cause for his non-appearance. Claimant not available beginning 10/29/2023. Dismiss remaining availability issue as moot.
The case should be reheard to collect additional details regarding the dates the claimant's parents were able to offer childcare. Therefore, modify the AT, good cause, rehear claimant availability due to childcare, and finally moot claimant availability due to school.
We have majority votes on the claimant had established good cause, that the second availability is moot, and we will rehear on the childcare availability issue. The two issues that had majority vote are also unanimous, so we'll resubmit after the rehearing.
Case number 3684439, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant filed a valid claim. Regarding the job separation, the employer alleged that the claimant was a no-call, no-show for 2 days by failing to properly notify her supervisor about technical issues that she was experiencing. However, the claimant provided credible, sworn firsthand testimony that she properly notified her team lead of the technical problem that she was having on both days by messaging her on Microsoft Teams, emailing her about the computer malfunction, and leaving a voicemail message. The claimant also contacted the employer's tech department and received ticket numbers for the reported technical problems. Therefore, the claimant was separated for reasons other than misconduct connected with the work. Modify the AT, valid claim, no misconduct, chargeback.
We should affirm the AT decision. First, I agree the claim was valid. Concerning the job separation, the claimant was absent without proper notice to the employer on multiple occasions. Claimant knew she needed to report to the office if her computer was not working, yet she failed to comply with this requirement. In light of the claimant's final warning, her actions constituted misconduct connected with the work. From the AT decision, valid claim, misconduct, no chargeback.
The employer's testimony that the claimant engaged in misconduct due to excessive absenteeism should be given significant weight, and they have met their burden of proof. Therefore, affirm the AT, valid claim, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3731995, Commissioner Trevino.
The AT decision should be affirmed. The claimant was separated from employment at the end of February of 2024 because her department had been privatized by a legislative mandate and the employer had no more work available for her. The fact that the claimant was offered a position with the new employer 4 months prior to her employment ending and did not take it, does not change the nature of the job separation to a quit. The claimant applied for the position with the new employer after turning down the offer before her employment ended and was not offered any other positions. Since the claimant's employment ended because the employer had no further work available for her at the time, the claimant was laid off due to lack of work. Affirm the AT, no misconduct, bill reimbursing employer.
We should reverse the AT decision. The claimant was offered a job by the new employer, which she rejected for personal reasons. Thus, the claimant initiated the job separation. There was no indication that the claimant had good cause to quit. We should reverse the AT decision, voluntary leaving, reimbursing employer not billed, adequate employer response.
This particular case should be reheard because the claimant's personal reasons for resigning may be non-disqualifying. Therefore, rehear to develop the record on the claimant's choice to resign for, quote, personal reasons, rather than transitioning to work for the new employer in March of 2024.
We have not yet achieved a majority vote. So we have one vote to affirm the AT, one vote to reverse the AT, and one vote to rehear the case.
I'll rehear it. Well, I'll support rehear.
Thank you. We will rehear the case.
Case number 3776228, Commissioner Trevino.
The AT decision is not correct. The claimant was told when she accepted the job that it was 100% remote and would remain that way. There were no restrictions on the claimant's remote working location. The claimant worked under these conditions for 2 years, but then was told that she was required to report in office 3 days a month. The claimant attempted to conform to the new working requirements to remain employed, but she found that this new requirement was not economically viable because that she had moved out of state. Though it took 3 months to make the decision, the delay was reasonable because the claimant was on medical leave for a month and reported for her in-office days the second month and was not required to work in office during the third month. Since the claimant quit due to significant change in her hiring agreement, the claimant had good cause connected with the work for quitting. Modify the AT, no voluntary leaving, void reimbursement.
We should affirm the AT decision. The claimant was able to comply with the employer's requirement that she report to work in person 3 days per month. Prior to officially moving out of state, she had been commuting back and forth for quite some time. Because the claimant failed to show that the employer's requirement was a substantial change to her hiring agreement or that the new working conditions were intolerable, she did not establish good cause connected with work for quitting. We should affirm the AT decision, voluntary leaving, void the reimbursement ruling.
The claimant has not established that she resigned with good cause, as the claimant's hiring paperwork and job description do not list the claimant's position as remote. Further, her teleworking agreement suggests that she was expected to return to work in person as needed. Therefore, affirm the AT, voluntary leaving, void reimbursement ruling.
Short form dissent.
Yes,
Voluntary leaving.
Yes, sir. I have it.
Case number 3781998, Chairman Esparza.
The AT decision should be affirmed. The claimant was asked to oversee a project during the weekend. Claimant's testimony reflects that he admitted to working weekends as necessary. And fact-finding statements from the claimant reveals that he was asked not once but twice to come in for a project in question. Nonetheless, the claimant did not show up for the project as requested. Since the claimant admitted to working weekends as necessary in the past, the employer's instructions were not unreasonable. Since the claimant failed to follow instructions when asked twice by an employer, he knew or should have known that his actions would lead to a discharge. Should therefore affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. The employer discharged the claimant for refusing to work on Saturday, which was outside of his regular Monday through Friday schedule. When the claimant's supervisor requested that the claimant work on Saturday with very little notice, the claimant notified the employer that he was unable to work on his day off due to family commitment. The claimant's inability to work overtime hours on his scheduled day off was not unreasonable, and the employer failed to provide any policy stating that the claimant was required to work weekends or evidence that he was advised that he could be fired for refusing to work overtime. Therefore, the claimant was separated for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The employer asked the claimant to come in on his day off on short notice and did not show that it was unreasonable for the claimant to say no. The employer did not appear for testimony. Therefore, I find that the employer did not meet their burden of proof in showing that the claimant's refusal to work on his regularly scheduled day off constituted misconduct. Reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir. That was the last case pulled for additional discussion on docket 34B. Turning now to docket 35B.
Case number 3676525, Chairman Esparza.
We should reverse the AT decision. The claimant was terminated for leaving the employer's premises with the company safe open and unattended. Although the claimant was unsure of the employer's policy, which required money to be kept in a locked compartment, the claimant left the employer's premises for an extended time with the safe open and money unattended. This violation, when combined with the claimant's failure to notify the employer about his extended absence from the store, constituted mismanagement of his position of employment. As such, we should reverse the AT decision. Misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant for violating their policy when he mistakenly left the safe open while rushing to the bank to get change for the store. The claimant testified that it was a hectic day and that his actions were not intentional or carelessness, and he performed his job to the best of his ability. Since the employer failed to present any direct evidence that the claimant's actions were negligent and that the claimant was unable to meet the employer's expectation, his discharge was for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant was terminated for misconduct because he acted carelessly when he left the store safe open and left the store without permission. Therefore, reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3704252, Chairman Esparza.
The AT decision should be modified. The claimant was discharged due to attendance issues. However, the claimant stated that her absences were due to needing to care for her child. The claimant also explained in their AT appeal that her son had a disability. As such, the claimant should continue to be qualified for benefits, and the employer's account should be protected from charge pursuant to Section 204.022A5 of the Act. We should therefore modify the AT decision. No misconduct, no chargeback, MVI.
The decision is supportable. The claimant's absence were due to the employer changing the schedule that she originally was hired to work, which caused the claimant to often miss work in order to take her disabled child to and from medical appointments. The claimant requested to be changed back to her original schedule several times, but her requests were denied. Additionally, the employer was not keeping track of the claimant's FMLA leave, which led to the claimant not knowing that her absences were not covered by FMLA. Therefore, the claimant's absence is due to her having to care for her disabled child following her schedule being changed was not misconduct connected with the work. Affirm the AT, no misconduct, chargeback. In the alternative, I could agree that the claimant's separation was directly related to her minor child's medically verified illness, so MVI provisions could be applied to this case. Modify the AT, no misconduct, no chargeback, MVI.
Yeah, in this case, I do not believe we should penalize either party, as both the employer and the claimant, it seems, did not realize the claimant had exhausted her FMLA leave. Because the claimant's leave was in relation to an MVI issue for her son, we should find no misconduct and no chargeback. Therefore, modify the AT, no misconduct, no chargeback.
We have a unanimous decision.
Case number 3734493, Chairman Esparza.
Commission should rehear this case. Claimant was separated when she became belligerent during a meeting with her manager. Although the parties disagree about the nature of the job separation, in her appeal to the commission, the employer alleges they can produce a firsthand witness and other clarifying information relevant to the final incident. As such, to properly determine the nature of job separation, a rehearing is required to obtain and review the employer's additional information. Please rehear.
The decision is supportable. The firsthand evidence presented in this case established that the claimant was discharged when her manager screamed at her and told her to get out prior to the end of her shift. The manager never contacted the claimant again, and although the claimant spoke with other managers, she was told not to return to the office and was notified that her manager had discharged her. Therefore, it was proper for the AT to conclude that the claimant was discharged and that the employer did not show that the claimant committed any misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Concur with Chairman Esparza, rehear.
We will rehear the case.
Case number 3735020, Commissioner Trevino.
The decision is not supportable. The claimant quit his job after his employer chose to transfer him to a new work location that was over 30 miles away due to a disciplinary action. Since the transfer offered by the employer would have required the claimant to travel significantly further away to his new location, the claimant had good cause connected with the work for quitting due to the longer distance. Reverse the AT, no voluntary leaving, bill reimbursing employer.
We should affirm the AT decision. The claimant had concerns about his working conditions. However, these stem from his own actions and continued absences due to personal reasons. The employer attempted to keep the claimant employed by offering him transfer to another location, but the claimant believed that the employer was trying to push him out, quote unquote. Despite the claimant's manager advising him to contact the director to discuss this situation, the claimant never did, nor did the claimant attempt to extend his FMLA leave. Thus, because the claimant did not give the employer a reasonable opportunity to remedy his concerns, the claimant quit without good cause connected with the work. From the AT decision, voluntary leaving, reimbursing employer not billed.
The claimant did not meet his burden of proof showing that he had good cause to quit because he did not provide evidence of any discriminatory practices against him by the employer. Therefore, affirm the AT, voluntary leaving, reimbursing employer not billed.
Short form dissent, ma'am.
Yes, sir.
Case number 3742475, Chairman Esparza.
The AT decision should be modified. The claimant showed up for work on the final day of the incident and was provided a delivery route to complete. The claimant refused to accept the delivery route and left the premises. The claimant's explanation for refusing the route does not excuse his action because it is the employer that has the authority to set schedules and assign the work of the company, not the claimant. By refusing to follow the employer's reasonable instructions and completing the delivery route in question, the claimant mismanaged his position of employment, which constituted misconduct connected with the work. We should therefore modify the AT decision misconduct, no chargeback.
The AT decision is not supportable. The claimant was discharged for refusing to accept delivery routes that had been assigned to other employee who was at work. The employer initially did not have a route for the complainant when he showed up for work. But as he was leaving, the dispatcher offered him other employee's route. The complainant had only ever been given another employee's route when the employee was out. Since the complainant did not have to take work away from another coworker who was present, he declined to the route. The employer did not advise the complainant that refusing the route would result in being discharged. Therefore, the employer requests that the complainant accept another employee's route was not reasonable under the circumstances, and his refusing to take the route away from his coworker did not constitute misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
Given that the claimant provided credible firsthand testimony that he reported to work and was terminated, we should analyze this case under the misconduct precedent. Accordingly, the claimant's refusal to comply with reasonable employer instructions constituted misconduct connected with the work. Therefore, modify the AT, misconduct, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3869643, Chairman Esparza.
The AT decision is fully supportable and should be affirmed. Claimant was fired for being insubordinate to his supervisor. Claimant denies refusing to carry out the supervisor's instructions. However, he admits confronting the supervisor and challenging his authority to reprimand or tell the claimant what to do. Claimant's actions were blatantly insubordinate and constituted misconduct connected with work. Affirm the AT decision, misconduct, no chargeback.
The decision is not supportable. The employer discharged the claimant after a verbal disagreement that he had with his supervisor about his assigned job duties. The employer alleged that the claimant was insubordinate and that he refused to perform the assigned task as instructed. The claimant provided credible firsthand testimony denying the employer's allegation that he refused to work and that the employer only provided secondhand hearsay testimony that the claimant's actions were improper. Therefore, the employer failed to meet its burden of showing that the claimant's actions were misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
There does appear to be insubordination and potential misconduct in this case. However, I'd be most comfortable with rehearing this case to better develop the record.
I'll support rehear.
Thank you. We will rehear the case.
Case number 3910992. Commissioner Trevino.
The AT decision is not supportable. Though the claimant signed an agreement with the employer agreeing to work as an independent contractor, the complainant worked under the employer's direction and control. The employer instructed the claimant regarding the performance of her work and threatened her with separation when she pointed out that she was being required to perform duties that were outside of her scope of work included in the contract that she signed. The claimant consistently worked for the employer for 5 years, and the employer required the complainant to have a set work hours and to notify the employer when she was to deviate from those hours. And she performed the work on the employer's premises and had submitted regular invoices in accordance with the manner required by the employer's payroll system. And she was paid regularly on a biweekly basis. And she was discharged and quit without incurring liability. Additionally, the employer required the claimant to submit a doctor's note prior to returning to work after the claimant missed work due to illness. Therefore, while the agreement between the parties stipulated that the claimant was an independent contractor, and the claimant believed that she was supposed to be an independent contractor, the evidence established that the employer instead exerted such direction and control over the claimant's work that the work was in employment, and the claimant should receive the requested wage credits based on the income received from the employer. Reverse the AT, claimant awarded wage credits in the amount of $13,242 for each base period quarter.
The AT decision is supportable. The record shows that the claimant was not in the company's employment, but rather was an independent contractor. She had her own company, her own federal employer identification number, performed work that was not a part of the company's business, worked under written contracts as she drafted, invoiced the company on a per-job basis, supplied the tools and materials for her work, could have hired her own assistants, set her own work hours, did not have to make reports to the company, was not trained or supervised by the company, could have worked for other companies, and represented herself to the company as an independent contractor. Under these circumstances, the claimant was not an employee of the company. Accordingly, we should affirm the AT decision. The claimant is not entitled to wage credits from the named company. I'm done.
Thank you.
Ms. Miller, before I proceed, just a point of order. We're on case 3910992. Is that correct?
Yes, sir.
Okay, very good. Thank you. As the named company did not exercise sufficient control over the claimant, and the claimant viewed herself as an independent contractor, the claimant should not be awarded wage credits for her custodial work. The AT decision should be affirmed. Therefore, affirm the AT, no additional wage credits.
Short form dissent, ma'am.
Yes, sir. Thank you. And that was the last case pulled for additional discussion on docket 35B, turning to 36B.
Case number 3132560. Commissioner Trevino.
And one moment, could you restate the case number?
3132560.
Please proceed. I'm showing 3132650.
50, that's what I showed too, ma'am.
Okay, Commissioner Trevino.
Okay. The commission has previously voted to deem the employer's CA appeal and the AT appeal timely. Regarding the work separation, the claimant quit her job due to intolerable working conditions. The claimant made good faith effort to resolve her concerns numerous times prior to quitting by notifying her direct supervisor and the CEO of her legitimate concerns. Despite this, the employer failed to properly acknowledge or address the issues with the workload and staffing shortages. Since the employer failed to address the claimant's reasonable complaints regarding the working conditions, the complainant had good cause connected with the work for quitting. Timely CA appeal modified the AT timely appeal, employer appeal, no voluntary leaving, chargeback, void adequate response.
We voted on a prior docket that the employer filed a timely CA and AT appeals. As to the job separation, the claimant quit her job due to feeling overworked. However, the claimant's recollection indicates that she was not asked to work after hours. In addition, to the extent that the claimant attributed health concerns to her reason for quitting, she did not see a medical professional about her stress, and a medical professional did not advise her to resign. As such, the claimant voluntarily quit without good cause connected with work. We should therefore find that the employer filed a timely CA appeal and reverse the AT decision. Timely employer appeal, voluntary leaving, no chargeback, adequate employer response.
Modify the AT, deem commission appeal timely, timely appeal, voluntary leaving, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3644718, Chairman Esparza.
We should reverse the AT decision. First, because the employer experienced technical issues registering for the hearing, the employer established good cause for its non-appearance. Concerning the merits, the claimant had received multiple warnings and was placed on probation for his performance. Therefore, we should have been aware that his job was in jeopardy. During the probationary period, the claimant removed cleaning supplies from his manager's vehicle to prevent her from doing her job. His actions were clearly not in the employer's best interest. Thus, in the absence of testimony from the claimant, the employer has met its burden of proving that the claimant mismanaged his position of employment. Accordingly, we should reverse the AT decision. The employer had good cause for its non-appearance, misconduct, no chargeback, adequate employer response.
The AT decision should be modified. The employer established good cause for their failure to appear at AT1. Regarding the job separation issue, the employer testified that the claimant was discharged for allegedly removing his manager's supplies from her car and telling her to go home. However, the employer presented no firsthand testimony from the manager or any witness to the final incident. The claimant gave statements to the claims examiner that he was instructed to remove the cleaning supplies from his manager's vehicle and denied the allegations of misconduct. Since the employer did not provide any direct evidence or firsthand testimony, the employer failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Modify the AT, employer established good cause for AT1, no misconduct, chargeback.
Modify the AT, good cause, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3672705, Commissioner Trevino.
The AT decision is not supportable. The claimant filed her claim in August of 2021 and was paid benefits until stop filing payment request in December of 2021. Over 8 months after the claim was filed and 4 months after the claimant filed last file for benefits, the commission issued determinations in the case. Since the claimant had been out of the claim status for several months by the time of these determinations were issued, she had no reason to expect to continue receiving such correspondence from the commission and was not regularly checking her electronic inbox. The delay in issuing these determinations amounted to commission misinformation, and the claimant's appeal should be deemed timely, and the case resubmitted for consideration due to merits. Reverse the AT, timely claimant appeal, resubmit.
We should affirm the AT decision. The claimant filed a late appeal because she was not checking her TWC inbox. Therefore, we do not have jurisdiction to consider underlying merits. Affirm the AT decision, late claimant appeal, voluntary leaving, no chargeback, overpayment.
The claimant's appeal should be deemed timely due to the TWC delay in this case. Therefore, modify the AT, timely appeal, resubmit.
We will resubmit the case.
Case number 3735871, Commissioner Trevino.
The decision is not supportable. The employer discharged the claimant for her handling of an incident involving a disruptive customer. The employer failed to provide any testimony or direct evidence that the claimant violated any known policies or procedures. The claimant testified that she reported the situation to her employer and was merely told to handle it as she saw fit. The customer provoked the claimant, escalating the situation, and the claimant was not provided any assistance from her employer when it was requested. Since the employer failed to provide any evidence regarding the claimant's actions during the final incident, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant did not follow company protocol when dealing with a customer in the employer's store. The claimant admitted to their policy for inappropriate customers is to ask them to leave the store, which the claimant didn't do. Instead, the claimant disclosed in a fact-finding statement that she used vulgar language toward the customer. Since the claimant did not follow company policy and because she used vulgar language toward a customer, her actions constituted misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
The employer here has not met its burden of proof in claiming misconduct because it provided no testimony nor evidence that the claimant engaged in wrongdoing. Therefore, reverse the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 3737734, Chairman Esparza.
We should affirm the AT decision. The claimant quit alleging health-related concerns. Although the claimant stated that his health condition rendered him unable to work, the claimant was never advised by a physician to quit. Furthermore, the evidence does not show that he attempted to remedy his concerns or request reasonable accommodations prior to quitting. Since the claimant quit when continued work was available, his separation was voluntary and without good cause connected with work. As such, we should affirm the AT decision, voluntary leaving, void the chargeback ruling.
The decision should be modified. The evidence presented established that the claimant resigned his position due to his inability to be on his feet for long periods because of a back injury that required surgery. While the complainant was not specifically told to resign by his doctor, he was told that he would need to be off his feet after surgery, and this position required him to stand for the entire shift. Therefore, because the claimant resigned because of the limitations imposed by his medically verified condition, he should not be disqualified under Section 207.045 of the Act. Modify the AT, no voluntary leaving, void chargeback.
The claimant should remain disqualified because he quit before requesting either accommodations or additional time off and did not receive a recommendation from his doctor to quit. Therefore, affirm the AT, voluntary leaving, void chargeback.
Short form dissent, ma'am.
Yes, sir. That was the last case pulled for additional discussion on docket 36B. Turning to docket 37B, which will be the last docket under this agenda item.
Case number 3220715, Commissioner Trevino.
The decision should be modified. I won't dispute the finding that the claimant did not establish good cause for missing AT1 and AT2 hearings. However, regarding the underlying timeliness and the PUA eligibility issues, timeliness sanctions should not apply because TWC did not issue the determination in this case until March of 2022, which was nearly 9 months after the claimant had stopped filing for benefits and his PUA claim had ended. Furthermore, the determinations were issued based on the conclusion that the claimant failed to provide proof of employment to justify the PUA claim by the 3/10/22 deadline. However, the claimant had submitted proof of employment documentation, including a tax return from the IRS for his business, and to TWC 6 days prior to the given deadline. Since commission records show that the claimant had already submitted the required proof of employment prior to the deadline provided, he was entitled to the PUA benefits that he received. Modify the AT, claimant did not have good cause for AT1 and AT2. Timely claimant appeal, PUA eligible beginning 12/27 of 20. No overpayment, timely appeal, void waiver.
We should modify the AT decision regarding good cause because the claimant was not checking his mail for AT2 and failed to provide a reason for missing AT1. He did not establish good cause for his 2 non-appearances. Concerning timeliness, the claimant filed late appeals to the PUA and overpayment determinations. I also agree that we should not take continuing jurisdiction over the PUA issue. Regarding waiver of the overpayment, the claimant filed a timely appeal to the waiver determination. Concerning the merits of this issue, since the claimant was partially responsible for the overpayment, denial of waiver is appropriate. And finally, while the claimant may have submitted some documentation to prove employment, he did not provide the acceptable documentation listed on the request form. Accordingly, we should modify the AT decision. The claimant did not have good cause for his 2 non-appearances, late appeals to the PUA and overpayment determinations, PUA not eligible beginning 12/27/20, overpayment, timely appeal to the waiver determination, deny waiver. I'm done.
We should grant good cause and deem the PUA and overpayment appeals timely because the TWC's extensive delays throughout the appeals process amount to misinformation and should not be held against the claimant. Further, the claimant presented sufficient evidence to show that he timely submitted proof of employment as instructed. Accordingly, the PUA and overpayment determinations should be reversed. Therefore, modify the AT, deem PUA and overpayment appeals timely, moot timeliness of waiver appeal, good cause for AT2 and AT1, claimant eligible for PUA benefits, no overpayment, void waiver.
This is a complex vote.
Yeah.
There's a majority vote on the no good cause issue from 2 commissioners. That's Commissioner Trevino, the chairman. There is a majority vote that the appeal was timely to the PUA and overpayment determination from Commissioner Trevino and Commissioner Conitt. And the underlying issues in the claimant's favor based on Commissioner Trevino and Commissioner Conitt.
And I'll short form dissent to that last one.
Short form dissent on the merits, the non-timeliness issues.
Hang on. Lady Payne. Yes.
Thank you. So the ultimate result in this one is the claimant receives the benefits.
Case number 3688346. Chairman Esparza.
The AT, what was that?
3688346.
Okay, thank you. The AT decision should be reversed. The employer provided sworn testimony that it was unable to access electronic correspondence due to being out of the country. After investigating, TWC personnel was only near certain that EBS would not block foreign IPs. Let me say that one more time. After investigation, TWC personnel was only near certain that EBS would not block foreign IPs. However, being near certain should carry less weight than the employer's firsthand testimony. Accordingly, the employer's protest should be deemed timely. We should therefore reverse the AT decision. Timely employer protest, remand.
The decision is correct. The notice of claim application was sent to the employer electronically on 11/17 of 23 and provided a response deadline of 12/1 of 23. The employer did not file their protest until 12/11 of 23 because the employer was out of the country. The employer's allegations that they could not access their online account while out of the country lacked any specific detail and could not be verified by the Commission's IT department. Therefore, since the employer filed a late response because they were out of the country and since there was no good cause exception to the timeliness rules, the protest was properly dismissed as late. Affirm the AT late employer protest.
Even if there was no way for the employer to have someone else check their mail or electronic correspondence while the representative was out of the country, we should still find that the protest was untimely because the employer sat idly by for 10 days after regaining access to the TWC correspondence. Therefore, affirm the AT late protest.
Short form dissent.
Yes, sir.
Case number 3705157, Commissioner Trevino.
The AT decision should be modified. I do not dispute that the claimant did not establish good cause for missing AT1. However, regarding the job separation, the available evidence established that the claimant's separation occurred when the employer insisted that she return to work in the office after she had been working remotely during her pregnancy. The claimant wanted to keep her job and requested to continue working remotely, but she could not return to the office because of the medical condition of her newborn child, who was born prematurely and needed both close monitoring at home and regular checkups with doctors. Therefore, since the claimant's separation was directly related to the medical condition of her minor child, it was not disqualifying reason for under Section 207.045 of the Act. Modify the AT. Claimant did not have good cause for AT1, no voluntary leaving.
We should affirm the AT decision. Concerning good cause, the claimant missed the hearing when she mixed up the date of the hearing with another scheduled hearing. Since the claimant missed the hearing due to circumstances were within her power to control, she did not establish good cause. Concerning the job separation, the claimant was separated when she did not report to work due to health concerns related to her child. Since the doctor did not advise her to resign, and moreover, since the claimant quit when continuing work was available, her separation was voluntary and without good cause connected with the work. As such, we should affirm the AT decision. The claimant did not establish good cause for missing the AT hearing, voluntary leaving.
It appears that the claimant has submitted clear medical documentation of her minor child's medically verified illness under Section 207.045D of the Act. Under these circumstances, we should find good cause and resubmit for the underlying merits testimony. Therefore, modify the AT, good cause, resubmit.
Ma'am, I'll agree with Commissioner Conick.
Thank you, sir. We will resubmit the case.
Case number 3720157, Commissioner Trevino.
The AT decision should be modified. I agree that the claimant had good cause for his failure to appear at AT1. However, regarding the job separation, the claimant's temporary assignment ended, and the claimant made himself available for reassignment by contacting his supervisor both before and after the last day of his assignment. His supervisor did not immediately respond to his attempts to contact her regarding available work, but later informed the claimant that there was no work available for him. Additionally, the claimant provided firsthand testimony that he had made himself available via the employer's online portal. And though the employer testified that they had no record of it, the employer provided no documentation or other evidence to support their testimony. Since the claimant attempted to report for a reassignment both by contacting his supervisor and via the employer's online system, yet the claimant was offered no additional work, the evidence established that the claimant was discharged for reasons other than misconduct connected with the work. Modify the AT. Claimant established good cause for AT1, no misconduct, chargeback.
We should modify the AT decision. First, I don't dispute the good cause ruling. Concerning job separation, the claimant did not follow the employer's reporting policy. Instead of contacting the employer immediately after the end of his assignment, the claimant contacted the employer 5 days later. Accordingly, he is considered to have quit without good cause connected with the work. Modify the AT decision. The claimant had good cause for his non-appearance, voluntary leaving, no charge back, sever adequate response issue.
Concur with Chairman Esparza on his analysis and vote. Modify the AT, good cause, voluntary leaving, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3732639, Chairman Esparza.
The commission should grant a rehearing in this case. It is not disputed that the claimant hit another vehicle that was disabled on the side of the road. What is disputed is whether the claimant committed misconduct connected with work for doing so. The employer stated that it reviewed video footage of the final incident, and it is not unreasonable to conclude that such a review contributed to the employer's decision to fire the claimant. As such, we should rehear this case and request that the employer submit its video footage of the final incident.
The decision is correct. The employer discharged the claimant for his involvement in an accident while operating a company vehicle. The employer alleged that the claimant's actions violated their safety or safe driving policy. While the complainant acknowledged hitting the disabled vehicle, he denied violating any company policy or driving in a dangerous manner. The claimant testified that he made a reasonable effort to avoid the collision, but was unable to do so because of a disabled vehicle that stopped partially in his lane, and there were another truck driving in the next lane, so he could not get over. Since the employer failed to present any direct evidence that the claimant was operating his vehicle in a negligent or dangerous manner, the claimant's separation was for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Would like to have this case reheard to further develop the record, please.
Yes, sir, we will rehear the case. And that was the last case called for additional discussion on docket 37B, and that ends agenda item 9.
Fantastic. Thank you. We will now turn to agenda item 10 for consideration of UI cases on docket 43. There are UI cases pulled for additional discussion. Is that correct?
Yes, sir.
Very good. Please proceed.
Yes, sir.
Case number 3205954, Chairman Esparza.
We should modify the AT decision concerning timeliness of the employer's appeal. The employer provided indisputable testimony of the non-receipt arising from mail delivery concern related to COVID-19. Since the appeal was late due to circumstances beyond the employer's control, we should find the employer's appeal timely. Similarly, the employer testified that the notice of application for unemployment benefits was received after the deadline for a timely protest. Since the employer's protest was late due to the delayed receipt, we should find the employer's protest also timely. As such, we should modify the AT decision: timely employer appeal, timely employer protest, resubmit for review and analysis of the rehear testimony.
Yes, sir, on the separation. Yes, sir.
The AT decisions are not supportable. The employer filed a late protest to the notice of claim and the late appeal to the initial determination. Although the employer's witness testified that he received the determination after the appeal deadline, the appeal was filed by a different person who indicated that the appeal was late because he was not coming into the office that much due to COVID. The appeal raised no allegations that the mail was received late, and the employer's witness could not explain the discrepancies. Therefore, the employer's allegation of receiving the determination late did not meet the burden or did not meet the credible and persuasive standard required to rebut the presumption of timely receipt, and the employer's appeal should be dismissed as late. Set aside the AT3 decision, reverse the AT1 decision, late employer appeal, and late protest.
We should find that the employer provided a late appeal and protest because they were unable to present credible and persuasive evidence of delayed delivery or misdelivery. Therefore, set aside AT3, reverse AT1, late appeal, late protest.
Short form dissent.
Yes, sir.
Case number 3662680, Commissioner Trevino.
The decision is not correct. The claimant, a special education teacher, was notified by the employer and the school's principal that his contract would not be renewed for the following school year. The claimant was not given a reason for the non-renewal and was told that it was in his best interest to resign. Since the claimant was given the option to resign rather than be terminated by the non-renewal of his contract, the employer initiated the job separation. While the complainant did not attempt or admit that he was experiencing some family and health issues, he otherwise performed his work to the best of his ability, and the employer did not provide any evidence that the claimant was warned about his job performance or that he engaged in any specific misconduct. Therefore, the claimant was discharged for reasons other than misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer.
We should affirm the AT decision. The claimant was recommended for non-renewal due to concerns related to his work performance. Although the recommendation was not final and required approval of the board, the claimant nonetheless quit. As the board did not affirmatively approve the non-renewal, and moreover, since the claimant quit in anticipation of a possible discharge, his actions constituted a voluntary quit without good cause connected with the work. As such, we should affirm the AT decision of voluntary leaving, reimbursing employer, not billed.
The claimant did not meet his burden of proving he voluntarily left with good cause because he submitted his resignation before any decisions regarding his employment status had been voted on by the school board. Although the school principal informed the claimant she would be suggesting his non-renewal, this was a mere recommendation. Therefore, affirm the AT, voluntary leaving, reimbursing employer, not billed.
Short form dissent, ma'am.
Yes, sir.
Case number 3711917, Chairman Esparza.
The commission should rehear this case. The employer in their appeal to a separate claim explained that there was an attempt to update their address on August 15th of 2023, well before the November 27th of 23 appeal deadline for this claim. Since the employer's correspondence shows a possible oversight by TWC to timely update the employer's mailing address, we should rehear this case to obtain testimony and additional evidence pertinent to a timely address change. Rehear, please.
The decision is correct. The employer's protest to the notice of the initial claim was submitted over a month late. Although the employer alleges that they did not receive the notice in a timely manner because it was mailed to their old address, the notice was mailed to the employer's address of record with the commission, and the employer did not submit an address change request to the commission until they filed their late response. Therefore, since the notice was properly mailed and no exceptions to the timeliness rules apply, the employer's protest should be dismissed as late. Affirm the AT, late protest, no misconduct.
The employer did not, quote, specifically request an address change with TWC in accordance with Texas Administrative Code Section 815.32. As such, I find no reason to disturb the AT ruling. Therefore, affirm the AT, late protest, no misconduct.
Short form dissent.
Yes, sir.
Case number 3726523, Commissioner Trevino.
The decision is not supportable. The claimant provided firsthand testimony that he did not receive the AT1 decision in a timely manner, which was corroborated by his petition to reopen, filed 2 days after the appeal deadline, stating that he had not received the decision until the day after the appeal deadline due to the delays in the postal delivery. Therefore, the claimant's petition to reopen should be deemed timely, and the case should be resubmitted for merits testimony. Reverse the AT, timely claimant petition to reopen, resubmit.
The AT decision should be affirmed. Claimant filed his petition to reopen after the applicable deadline to do so had expired. The claimant's testimony as to when he received the AT decision in question did not rise to the level of credible and persuasive such that it would constitute an exception to the timeliness rules. Therefore, the claimant's petition should be dismissed and the underlying decision should remain in full force and effect. Accordingly, we should affirm the AT decision, untimely claimant Rule 16 petition to reopen, timely employer protest, misconduct, no chargeback, adequate employer response.
The claimant failed to establish a timeliness exception because he did not provide uncontradicted testimony of late receipt. Therefore, modify the AT, late petition to reopen, timely protest, misconduct, no chargeback, sever adequate employer response.
If there's a late petition to reopen, there's no jurisdiction to sever. The chairman voted to just leave that in effect.
That's fine. I'm happy to concur with the chairman on that matter.
Thank you, sir.
Short form dissent, ma'am.
Yes, sir.
Case number 3733869, Commissioner Trevino.
The claimant's continued claim involving his work for a marketplace employer in self-employment. As such, there is no separation from employment, and the continued claim dated January 27, 2024 should be voided. Set aside the AT decision, void the continued claim. no overpayment.
The AT decision should be affirmed. I don't contest the timeliness of claimant's appeal. As to the job separation, claimant concedes that he took 2 weeks off of work for personal reasons. Thus, claimant's job separation was voluntary and without good cause connected with the work. Affirm the AT decision, timely claimant appeal, voluntary leaving, overpayment.
The claimant's work as a gig driver was not in employment, thus there was no separation. The claimant's honest reporting of temporary gig work should not result in the claimant's disqualification. Therefore, set aside the AT, timely appeal, void the continued claim, no overpayment.
Short form is that.
Yes, sir.
Case number 3736651, Commissioner Trevino.
This case involves a continued claim related to the claimant working as a marketplace contractor in self-employment. As such, there was no separation from employment and the claimant's additional claim should be voided. Set aside the AT decision, void the additional claim.
The AT decision should be affirmed. The claimant voluntarily reduced her hours while there was still work available for her. In addition, the claimant admits that she quit because the job wasn't a good fit. Therefore, the claimant's job separation should be considered voluntary and without good cause connected with the work. Affirm the AT decision, voluntary leaving.
The claimant's work as a gig driver was not in employment, thus there was no separation. The claimant's honest reporting of sporadic gig work should not result in the claimant's disqualification. Therefore, set aside the AT, void the additional claim, but I am requesting a memo to investigate ability and availability.
There's a majority vote to void the claim, and I will send the memo, sir. Do you wish to dissent?
Yes.
Thank you, sir.
Short form is that.
Yes, sir.
Case number 3737719, Commissioner Trevino.
The decision should be modified. I do not contest that the employer established good cause for its failure to appear at AT1. However, regarding the job separation, the claimant was a 20-year employee who had never received any kind of written warning and was discharged after a single incident of giving the wrong settlement check to a client. The claimant immediately realized his mistake and gave the correct check to the client before they left the premises. Though the employer alleged that the claimant's work performance had declined in the weeks before this incident, the claimant was never given a written warning, and the employer acknowledged that the claimant had never made this type of mistake before. Therefore, the employer has failed to establish that the claimant's actions constituted misconduct connected with the work. Modify the AT, employer established good cause for AT1, no misconduct, chargeback.
The AT decision should be modified. First, I agree that the employer established good cause for missing the AT hearing. Concerning job separation, the claimant concedes that he missed pertinent steps in the delivery of a settlement check, and the claimant handed an incorrect settlement check to the employer's client. Due to this mistake, the claimant potentially exposed the employer to severe penalties, as compromising confidential client information may have cost the employer their law licenses. As this incident is severe, commission precedent established that it was reasonable to discharge the claimant for this incident alone. Therefore, the claimant was discharged for misconduct connected with work, and the AT decision should be modified. The employer had good cause for missing the AT hearing, misconduct, no chargeback, adequate employer response.
The claimant's failure to ensure that he gave the client the correct check was negligent and exposed the employer's business to potential harm. As such, he was terminated for misconduct. Modify the AT. Good cause, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3746053, Commissioner Trevino.
The decision is not supportable. First, the claimant had good cause for missing AT1 since she made a good faith effort to participate and only was 1 minute late in registering for the hearing. Regarding the job separation, the claimant was hired for one position, but the employer later informed her that the position was overstaffed. The employer told the claimant that she could be placed in a different position, but she had to take a training class and a state licensing exam. The claimant took the training class but did not pass the exam and was only allowed one attempt before she was discharged. Since the claimant was originally hired for a position that did not require an exam, then was effectively laid off from the position, but made a good faith effort to attempt to retain employment by agreeing to take the exam, the claimant's inability to pass the exam did not constitute misconduct connected with the work. Reverse the AT, claimant had good cause for AT1, no misconduct.
The AT decision should be modified. First, I don't contest the good cause issue. As to the job separation, the claimant was aware that the initial hiring agreement was changed due to her work on another project. She consented to these changes, but she failed to obtain the required license for the role. Consequently, the claimant mismanaged her position of employment and was discharged for misconduct connected with the work. For this reason, we should modify the AT decision. The claimant established good cause for missing the AT hearing, misconduct.
Modify the AT, good cause, misconduct.
Short form dissent, ma'am.
Yes, sir.
Case number 3755626, Chairman Esparza.
We should reverse the AT decision. The claimant worked as a registered nurse for the employer. Although the claimant was repeatedly offered further work assignments, she refused to respond to the employer's text messages or accept any offers for additional work. Since the claimant did not accept further assignments when continued work was available, her separation was voluntary and without good cause connected with the work. As such, we should reverse the AT decision, no chargeback.
The decision is correct. The claimant performed on-call work and worked an irregular schedule on an as-needed basis for the employer. Since the claimant did not know at the end of each assignment when or whether further work would be available, the claimant was involuntarily separated for reasons other than misconduct at the end of each shift. Therefore, the employer's account should remain charged. Affirm the AT, chargeback.
The employer's account should not be charged because it offered the claimant multiple reassignments before she filed her unemployment claim. As the claimant voluntarily declined the reassignments offered to her, it was her choice to separate from the employer. Therefore, reverse the AT, no chargeback.
Short form dissent, ma'am.
Yes, sir.
Case number 3758494, Chairman Esparza.
The AT decision should be reversed. The claimant concedes to making inappropriate sexual remarks to a coworker, and these comments were then reported. The employer investigated this further, which led to the claimant's discharge as he violated the company's policy on harassment. The claimant was aware of the employer's harassment policy, and the employer has an interest in maintaining a harassment-free workplace. Therefore, the claimant was discharged for misconduct connected with work, and we should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant for making an improper comment directed towards a coworker. The claimant admitted that his comment was inappropriate, but was also testified that the two of them frequently made similar comments to each other in a joking manner, and that there wasn't any harmful intent. Since these comments were the manner in which the two often communicated with each other, and because the claimant's remarks were directly responding to the similar comment initiated by the other employee, the claimant was unaware that he was violating any policy, and his actions should not be considered misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant was terminated for misconduct because he mismanaged his position of employment by using vulgar language in the workplace. Therefore, reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir. That was the last case pulled for additional discussion on docket 43. You should have received the short form dissent list for docket 43, the unemployment insurance short form dissent list.
I move that we accept staff recommendations on the remaining UI cases on docket 43.
I second the motion except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 43.
I concur with the Commissioner's motion except for the cases on which I'm dissenting as reflected in UI short form dissent list for docket 43.
The motion passes with the exceptions noted.
Mr.
This concludes agenda items 3 through 10. Chairman Esparza, I hand the meeting back to you for the conclusion.
Okay, well done, everybody. Terry Miller, thank you, your CA team for keeping all this on track
Thank you,
and
sir.
organized. So everybody, thank y'all for hanging in there.
It's our
We'll
pleasure.
take we're going to pause now for a short break and allow exchange. So we're on recess. Okay, welcome back. Item 11, discussion, consideration, possible action for information submitted to LBB and ranking of agency programs.
Good afternoon, Commissioners. Mr. Townsend. For the record, Caitlin Pearson, Director of Budget and Fiscal Policy with Finance Division. TWC is currently undergoing strategic fiscal review by the Legislative Budget Board, as required by Senate Bill 68, enacted by the 86th Legislature. SFR is required to be held concurrently with the agency's Sunset Advisory Commission review. TWC will provide detailed programmatic and financial information, which will result in a report submitted by LVB to the governor, lieutenant governor, and legislature. As a part of this process, TWC is asked to rank its programs in priority order in alignment with our agency's goals, objectives, mission, and statutory authority. Staff have developed the weighted criteria and program rankings presented before you today, including those criteria just mentioned, along with program funding, relation to workforce, customers impacted, and impact to agency infrastructure functions. That concludes my remarks, and I'm happy to answer any questions you may have.
Thank you, Caitlin. Commissioner Trevino, any questions or comments?
Nothing here.
Commissioner comment?
Yes, thank you, Chairman. I just want to verify, is it correct that this exercise is a function, is a required function that we're engaging in with the LBB, and we don't anticipate that any funding cuts will stem from this exercise and from this ranking? Is that correct?
No. A part of the exercise with LBB is to provide the programmatic and financial information. And one part of the exercise is to provide what the agency anticipates would be the minimum funding required to operate the program. But beyond that, that's the information we're providing to LBB. But nothing specifically related to the rankings.
Very good. Thank you.
Thank you, Caitlin, for the presentation. Do I have a motion?
Chairman, I move that we approve the Strategic Fiscal Review Program ranking for submittal to the Legislative Budget Board as recommended today by staff.
Second.
Also vote yes, motion passes. Thank you, Caitlin.
Thank you.
Appreciate it. Agenda item 12, possible action regarding approval of local workforce development board nominees.
Good morning, Chairman, Commissioners, and Mr. Townsend. For the record, my name is Kara Levy with the Workforce Development Division. Today, for your consideration, we are presenting Workforce Board nominations for the following boards: Cameron County, North Central Texas, Heart of Texas, Golden Crescent, Middle Rio Grande, Northeast Texas, West Central Texas, Permian Basin, South Plains. Staff recommends approval of the nominees as presented. I'm happy to answer any questions you have.
Thank you, Kara. Commissioners, any comments or questions?
None here.
Yes, sir. Thank you, Chairman. One comment on this item. I greatly appreciate all of staff's really very hard work in compiling and reviewing these nominees. I'd be in favor with moving forward on all of these boards, these slates of nominees, with the exception of West Central Texas. I have some questions I'd like to pose with staff about that particular group of nominees. Therefore, I request, and I'm prepared to make a motion, postponing consideration of that board to a future meeting while approving the remainder, as I understand that some of them are time sensitive in connection with the next agenda item.
There's a motion.
I would move the preceding that we postpone consideration of the local workforce development board member nominees for West Central Texas, and that we approve nominees presented for Cameron County, North Central Texas, Heart of Texas, Golden Crescent, Middle Rio Grande, Northeast Texas, Permian Basin, and South Plains.
And I'll second.
I also vote yes, and motion passes to several West Texas, or Central West Texas, to next appropriated meeting.
Thank you.
Okay. Yep. Thank you very much. I think we got that right.
I'm next also. For the record, Kara Levy with Workforce Development Division. We're presenting Workforce Board subsequent certifications. In accordance with the Workforce Innovation and Opportunity Act, WIOA, the government is required to certify one local workforce board for each workforce area every 2 years. This certification process validates that each board meets the required composition criteria and that its workforce investment activities continue to support strong performance under WIOA accountability measures. Staff has reviewed all 28 boards, verifying board creation, appointments, and composition requirements, as well as alignment with state and federal law. Based on this review, staff determined that all 28 boards are in full compliance with the subsequent certification requirements. Staff recommends submitting to the Governor, Texas Workforce Commission's subsequent certification approval for all 28 workforce development boards. I'm happy to answer any questions you have.
Thank you. Commissioners, any questions, comments?
Nothing here.
Just a follow-up question from agenda item 12. Does our, pause on voting on the West Central Texas nominees does that mean we then need to sever them from this vote on agenda item 13?
Good afternoon, Patricia Martinez, Workforce Development Division. No, sir, all boards remain compliant even without West Central Texas.
Very good. Thank you for verifying.
Thanks for checking. Anything else?
Nothing here.
Comments or questions? Do I have a motion?
Chairman, I move that we approve the submission of the governor and the recommended subsequent certification of the 28 local workforce development boards as presented today by staff.
I second.
I also vote yes, motion passes. On to item 14. Thank you all very much.
Thank you.
On to item 14, no action 15, no action 16. It's our Executive Director's report.
Thank you, Chairman, Commissioners. Just will mention that during this transition period, we're continuing to continue the operations of the agency and all the daily business with the support of all our excellent leadership team and staff of the agency. So just wanted to let you know all things are continuing as you would have expected. So that was it.
Great.
This morning or this afternoon, I guess.
Thank you, Randy. Did we forget Brent? Brent, did we forget you on anything? I don't think so.
Mike, no.
I think that's it. With that, agenda item 18, no agenda item 18. And come to the end of the agenda. Do I hear a motion to adjourn?
Chairman, I move to adjourn.
I second the motion.
All that motion is made and seconded and passes. Meeting is adjourned. Thank you.